Barron Trump, the youngest son of former President Donald Trump, has largely stayed out of the public spotlight since his father left office. While other members of the Trump family remained heavily involved in political and media activities, Barron appeared to be carving a different path, one that leaned more toward academia and personal growth, rather than public confrontation. That's why the lawsuit he filed against Congresswoman Jasmine Crockett took many observers by surprise. It wasn't just that he sued a sitting member of Congress, it was what the lawsuit claimed, and what it revealed about his concerns regarding his own future image. The heart of the case was not political disagreement. It wasn't a dispute over legislation or partisan ideology. Instead, it was deeply personal. Barron Trump claimed that Representative Crockett, during a closed-door ethics committee session, made remarks that amounted to character assassination. According to the lawsuit, Crockett had suggested that Barron was connected to specific right-wing groups, known for promoting radical views online. She had allegedly implied that his public silence on controversial issues was not neutrality, but a deliberate tactic to mask deeper ideological leanings. His legal team argued that such statements, even if made behind closed doors, had begun to seep into the media ecosystem, causing reputational harm. For Barron, this seemed to be a moment of reckoning. After years of being largely shielded from public critique due to his age, he was now a legal adult. He had begun showing signs of stepping into the world more publicly, reportedly exploring interests in technology, business, and even policy. Think tanks. Any hint of association with fringe political ideologies, particularly ones that he believed he had no involvement in, could derail future ambitions. The lawsuit was framed not as a political counterattack, but as a necessary defense of his attempt to assert control over how he would be seen by peers, institutions, and potential collaborators. His team asserted that Crockett's comments were not only reckless but factually unfounded. They emphasized that she had never spoken to Barron personally, and had relied on what they described as distorted interpretations of his limited social media presence. The concern was that her statements, because of her status as an elected official, carried weight. Her words could suggest a legitimacy that might influence how the public, universities, and potential employers perceived him. In that sense, the suit was less about punishing a political adversary, and more about trying to draw a line around what was fair game when it came to public commentary, especially regarding someone who had, up to this point, chosen a quieter path. Barron's legal team leaned heavily on the principle that personal reputations should not be casually sacrificed in the arena of political speech. They pointed out that while his last name carried weight, he himself had made deliberate efforts to remain outside the political fray. If public figures like Crockett could make sweeping claims without direct evidence, what protections did any individual have in today's environment? The suit was as much a reflection of modern anxieties about reputation in the digital age as it was a traditional defamation case. Interestingly, the complaint made no effort to allege malice. Barron did not accuse Crockett of intending to ruin his future. Instead, the legal language focused on negligent disregard for factual basis, and the unjustified projection of ideological motives onto a private citizen. In other words, the case was built on the argument that he had been mischaracterized not through targeted malice, but through the careless wielding of political rhetoric. This careful framing painted Barron not as an aggressor, but as someone reluctantly entering legal territory to preserve what he viewed as his personal dignity. It was a subtle but significant difference. Rather than demanding retraction or apology through public spectacle, he sought to engage the legal system in order to draw a firmer boundary around what could be said, especially by those in power, about someone who had not actively engaged in political discourse. The lawsuit, in essence, was an effort to clarify where the line lies between fair critique and harmful speculation. On the second day of the hearing, Barron Trump's legal team was riding on the momentum of their carefully constructed case. They had presented hours of testimony to establish that Congresswoman Jasmine Crockett's remarks were damaging, speculative, and made without proper evidence. Expert witnesses had spoken about reputational risk, the nuances of defamation law, and how statements, even if made behind closed doors, could find their way into the public consciousness in the age of rapid digital circulation. The courtroom had maintained a restrained and orderly tone. Both sides were professional, even cordial, but the tension beneath was unmistakable. Crockett's team had been relatively quiet through much of this, letting the plaintiff's argument unfold without much interruption. But as the second morning began, they called their first and only expert witness, Dr. Leonard Harland, a retired professor of media law from Georgetown. Known for his meticulous scholarship and calm demeanor, Harland was not a flashy figure. He walked with a slight hunch, carried a worn leather briefcase, and spoke in measured tones. Many in the courtroom assumed his testimony would be dense and academic, perhaps useful, but unlikely to shift the emotional tone of the trial. Instead, it changed everything. Harland took the stand and was sworn in. He was handed a printed transcript of Crockett's remarks, those made during the committee session in question, The courtroom grew quiet as the defense attorney approached with what appeared to be a simple line of questioning. There was no dramatic build-up, no theatrics, just one straightforward inquiry. Dr. Harland, based on your review, were the statements made by Congresswoman Crockett factually baseless? Harland paused for a brief second, pushed his glasses up the bridge of his nose, and answered with remarkable clarity. Not only were they paraphrased from public sources, Barron's own social posts, but no false statement was made. This is political discomfort, not defamation. It lasted exactly 9 seconds. 9 seconds that deflated the narrative built over the previous day and a half. The courtroom shifted slightly, as if people weren't sure whether they had just heard something significant. But within moments, it was clear. This wasn't merely an opinion. It was an expert dismantling the core allegation of the case in one carefully worded sentence. The statement's power lay in its precision. Harland didn't just say the remarks were not defamatory. He went a step further, pointing out that the comments were rooted in existing, public material statements and images that had already been shared online voluntarily. That single point reframed the conversation. If the information had been publicly available, if it was already out in the open through the subject's own actions, how could citing or interpreting it rise to the level of legal harm? The other half of his answer was just as important. Harland labeled the reaction to Crockett's comments as political discomfort, a subtle but devastating phrase. It suggested that the hurt or embarrassment being claimed wasn't rooted in falsehood, but in the way public life often invites scrutiny, especially when tied to a figure with national recognition. Harland's words drew a line between public unease and actionable legal harm. One was a reality of life in the modern media age. The other required a far higher burden of proof, one that simply hadn't been met. The plaintiffs tried to challenge the assertion during cross-examination, but Harland didn't waver. When asked whether it was fair for a public official to draw conclusions from social media posts, he calmly responded, "That's what most public discourse today is. Interpretations, not inventions." The implication was clear. Unless something blatantly false had been created and attributed, there was little legal basis for calling it defamation. As the morning moved on, the courtroom felt quieter, more subdued. The statement's impact lingered not because it was loud or emotional, but because it left no air in the room for rebuttal. The rest of the trial, while procedurally necessary, had lost its sense of momentum. Even those unfamiliar with the nuances of defamation law could tell that something fundamental had shifted. The witness had not offered a dramatic takedown or a stirring speech. He had done something more unsettling to the plaintiff's legal team. He had made their argument irrelevant. When the judge returned from recess on the third day of the hearing, it became clear that the tide had turned. The previous day's 9-second testimony by Dr. Leonard Harland had not only undercut the plaintiff's primary claim, it had also the legal question at the heart of the case. Suddenly, this wasn't just about Barron Trump's personal reputation, it was about what counted as actionable speech in a political and public context. As the court resumed, the judge made a series of procedural remarks, subtly signaling that the central legal argument had been weakened. The defense seized the moment, shifting its strategy to focus more directly on the broader implications of political discourse in a democratic society. Jasmine Crockett's legal team leaned heavily on Dr. Harland's statement, repeating his phrasing to reinforce the idea that this was, at its core, political discomfort, not defamation. This reframing placed the lawsuit in a new light. The court was no longer being asked to determine whether a single individual had been wronged in a personal sense. Instead, it was being asked to evaluate whether a member of Congress, speaking in a closed-door committee session and referencing publicly available material, could be held legally liable for how her words were interpreted outside that room. Dr. Harland's calm, precise analysis served as the fulcrum for that shift, providing both the legal and ethical justification for defending Crockett's right to speak. The judge began to question the intent behind the lawsuit more openly. In a quiet exchange during the third day's arguments, he asked the plaintiff's attorney, "Are we here to discourage public figures from commenting on the digital behavior of other public individuals? Or are we drawing a clear line around malicious fabrication?" It was a rhetorical question with a sharp edge. The implication was unmistakable. The burden of proof in a defamation case isn't just about proving harm, it's about proving falsehood and malicious intent. And with Harland having established that the source material for Crockett's comments came from Barron's own social media presence, the defense had a solid footing to argue that no fabrication had occurred. The larger legal precedent that began to emerge was rooted in First Amendment principles. Political speech, especially when it involves public figures, is held to a very high standard of protection in U.S. courts. This is because democracy depends on open debate, even when that debate makes some uncomfortable. Dr. Harland's testimony emphasized that the role of elected officials includes interpreting trends, ideas, and behaviors that affect policy discussions even when those interpretations are controversial. In this case, Crockett had referred to social posts and public associations that raised questions for her as a lawmaker. That she voiced those concerns internally during a policy discussion was not only legally protected, it was functionally part of her job. Barron Trump's legal team attempted to push back by arguing that even public figures deserve boundaries, and that reputational damage can be deeply personal and long. But they struggled to overcome the implication left by Harland's testimony that discomfort does not equal damage, and that interpretation is not the same as invention. His carefully chosen language became a quiet refrain throughout the closing arguments. The defense repeated it deliberately. Political discomfort, not defamation. Observers in the courtroom noted how the tone of the proceedings had subtly changed. Early on, there was a sense that this was a high-profile defamation case with personal stakes. But by the end of the third day, the case began to feel more like a constitutional test. Were lawmakers going to be punished for referencing public material? Would the court set a precedent that chilled speech every time a statement made someone uncomfortable? The answer seemed to crystallize through the lens of Harland's testimony. His calm delivery, backed by decades of scholarship and a deep understanding of constitutional protections, helped anchor the defense's claim that Crockett had stayed within legal and ethical bounds. He never attacked Barron Trump personally, nor did he politicize the issue. Instead, he clarified the essential point. In a society where public figures engage in public discourse, and where commentary is often based on publicly available behavior, the legal bar for defamation must remain high. Anything less would risk transforming courts into tools for silencing disagreement rather than settling genuine harm. Throughout the course of the lawsuit, Jasmine Crockett's demeanor never shifted dramatically. From the initial filing of the complaint to the final day in court, she maintained a measured, almost indifferent posture that stood in contrast to the high-profile nature of the case. While media outlets speculated about her next move and pundits debated the optics of a young Trump taking legal action against a sitting Congresswoman, Crockett declined to feed the narrative. She issued no statements of outrage. She didn't take to social media to refute the claims directly. Instead, she allowed the legal process to unfold, and quietly placed her trust in the strength of her defense. Her calmness wasn't born of inattention or disregard. It was a strategic choice. Crockett, a former public defender turned legislator, understood the weight of public scrutiny. She knew that overreacting, especially in the media, could easily be framed as arrogance or provocation. So she stayed quiet, keeping her commentary to a minimum, and letting her legal team do the talking in the courtroom. When asked by a reporter outside the courthouse if she planned to fight back hard, she simply replied, "I don't have to fight when I have the truth." That statement reflected more than just personal confidence. It spoke to a philosophy of resilience. Crockett believed that truth had a way of asserting itself, even when emotions ran high. Her legal team followed her lead, presenting a defense built not on fiery rhetoric, but on careful legal framing, supported by credible expertise. And no piece of that defense was more effective than the testimony of Dr. Leonard Harland. When Dr. Harland took the stand and delivered his concise analysis, it didn't just serve a legal function, it mirrored Crockett's own approach. His matter-of-fact dismissal of the plaintiff's central claim underscored the power of factual clarity. He didn't ridicule the opposing side. He didn't raise his voice or try to score rhetorical points. He simply stated, in under 10 seconds, that the statements in question were based on publicly accessible information and did not meet the standard for defamation. That clarity didn't just undercut the case, it validated Crockett's confidence in the truth. Rather than deliver a series of counter-accusations, Crockett and her team relied on Harland's measured authority. His statement became a foundation around which the rest of the defense was built. Every time the plaintiff's attorneys returned to their central claim that Barron Trump had been unfairly characterized, Crockett's team gently redirected the conversation back to Harland's observation. If the source material was public, if the comments were interpretive, and if no demonstrable falsehood had been presented, then the case had no legs to stand on. Crockett's decision to remain composed through the process turned out to be one of her most powerful strategies. She didn't just win on legal grounds. She reinforced the idea that public figures can respond to pressure with transparency and integrity, rather than deflection or escalation. It sent a quiet message that strength doesn't always look like aggression, and sometimes it looks like discipline. This discipline was on display during her brief post-verdict remarks. While media crews waited outside the courthouse for a statement, Crockett emerged, flanked by her legal team, and thanked the court for its time. She offered no victory lap. Instead, she made one brief comment. In a democracy, words matter, but truth matters more. She didn't name Barron Trump. She didn't allude to political motives. The statement was broad enough to be universal, yet unmistakably tied to the principle that had guided her from the beginning. Dr. Harland's testimony, modest as it was in tone, gave Crockett exactly what she needed, not just a legal advantage, but a quiet confirmation that her restraint had been justified. His statement became a symbol of how careful reasoning could cut through noise. and how calm professionalism could carry more weight than outrage. Crockett didn't need to react to the lawsuit with emotion or media spin. She allowed facts, law, and steady resolve to lead the way, and in the end, that approach proved more effective than any heated rebuttal could have been. Asterisk. As the case drew to a close, and the courtroom emptied, the significance of what had just transpired extended far beyond the immediate parties involved. What began as a lawsuit over a few pointed remarks had evolved into a broader conversation about speech, public life, and the boundaries of interpretation in an age where nearly everything is recorded, shared, and analyzed. Barron Trump, by stepping into the legal spotlight, made it clear that he was serious about shaping how he is perceived in the public eye. His lawsuit was, at its core, a demand for accountability, a pushback against the casual nature of political commentary when it turns personal. Whether his motivations were strategic, principled, or emotional, the case served as a statement: reputation matters. Even when you're not the one speaking the loudest. But the legal system, by design, favors precedent and principle over sentiment. In this case, the principle was clear. Speech by public officials, especially when based on public information, is afforded wide latitude under the law, and the burden of proving defamation, falsehood, harm, and intent is not easily met, particularly in the world of political dialogue. Dr. Leonard Harland's brief but powerful testimony was a reminder of the role that reason and scholarship can still play in moments clouded by public spectacle. His calm, unembellished words dismantled a central argument and reminded everyone that clarity often carries more weight than emotion. His contribution didn't just protect one defendant, it reaffirmed a legal standard that guards against the misuse of courts to settle ideological disputes. Jasmine Crockett's quiet confidence, her refusal to lash out or engage in media theatrics, reflected a kind of leadership that many found refreshing. Rather than matching accusations with counterattacks, she let the process work. She let truth speak through structure. Her trust in the system and in the expertise supporting her paid off in a way that was both legally decisive and publicly dignified. This case won't be remembered for fiery moments or dramatic courtroom clashes. It will be remembered for its restraint, for how two very different approaches to public life met in court, and how, ultimately, facts prevailed over speculation. Barron Trump may not have achieved the outcome he sought, but his willingness to pursue legal clarity set a precedent of its own, that even in a noisy world, the desire to defend one's name is still taken seriously. And as for Jasmine Crockett, she walked away not just with a legal victory, but with her credibility intact, not by slogans or sound bites, but by the strength of calm resolve